Good evening, everyone. I welcome you all for second Shyamlha Pappu Memorial Lecture on access to justice in the context of the 75 years of Indian Constitution. So before starting the program, I request our dignitaries on the dais to just lit the lamp. Let us start the program.
फोटोग्राफर की डिमांड होती है ये। हमारा तो साथ में हो जाता है। तुम भी जलाओ, गले को जलाओ, दीप से दीप जलाओ।
I welcome Dr. Adish Agarwal ji, Senior Advocate, President Supreme Court Bar Association. And I also welcome Shri Honorable Mr. Justice K.V. Vishwanathan, Judge Supreme Court of India. And I also welcome Honorable Mr. Justice Abhay S. Koka, Judge Supreme Court of India. And I also welcome K.K. Rai ji, Senior Advocate. And I also welcome our trustee R. Krishna Murthy ji. So now I request Mr. Arya ji and K.S. Bhati ji to welcome our President Adish Agarwal ji.
मैडम
सर मुझे जो सीक्वेंस में दिया
वो
गया
सीक्वेंस वो नहीं है, मैं बोलूँगा पहले, मैं छोटा हूँ।
सर भी मैं सर जो स्पेशल गेस्ट है तो इसीलिए हमने उनके लिए वो रखा था कि भी आपका पहले कर
सर हाँ पहले तो पीछे अच्छा लगेगा।
Now I request Senior Advocate K.K. Rai and Advocate Nepal Singh to welcome our Judge Justice K.V. Vishwanathan, Judge Supreme Court of India. सर अब आपका वेलकम कर लें। Now I request Neelam and Vijay Lakshmi to welcome K.K. Rai ji. Thank you so much. Before starting the program, we have a very short film on the life of late Dr. Shyamlha Pappu, Padma Shri Awardee, Senior Advocate, and activities of the Shyamlha Pappu Law Foundation. So let us have a look.
Which one you?
I was not born at that time. I was not.
बच्चे जो थे
So वैसे अगर ये थोड़ा सा बता देते ना
तो माइक के बोलते जाओ आप बोलते जाओ यहीं से बोलो अपने माइक से ऐसा होता था
This is a photo of the Delhi University Students Union as the executive committee member. This is the Afro-Asian Conference, and in this photo you are seeing Mr. K.N. Bhatt, who was later the Additional Solicitor General. This is the Zonta cafeteria, which ran the Delhi High Court canteen. In Delhi High Court canteen. Ladies only. This is in the old Patiala house. Before the High Court was in the Patiala house. Mr. Vijay Bhaskar Reddy was and Justice A.P. Shah, Chief Justice of the Delhi High Court. And Justice M.N. Venkatachalaya. This was when she was conferred the Mahila Shiromani Award. Here you will see Ms. Vidya Karthikeyan. She, the Governor of Karnataka, Mr. H.R. Maharaj. Here you will see Najma Astrology, who was the deputy chairperson of the Rajya Sabha. These are the old writings in the middle of her. This is the ladies delegation of the All India Women's Conference. This is with Madam Indira Gandhi. He is Dala Omar, the minister in South Africa. You will see Sushma Swaraj. Her senior was A.S.R. Chari, a well-known name in the bar. You have seen Mr. Atal Bihari Vajpayee. This is on the occasion of this is Nektur Srinivas Rao, the Chief Justice of the Karnataka High Court. So you must be knowing him. Awarded in 2009. Now we come to the activities of the foundation. These are our legal awareness camps in the villages, neighboring villages of Delhi. And as in all camps, eating is also very important. This is a middle by well-known Indra Jaisingh, who actually she is also an advisory board member. She said she will be here, but unfortunately she had to go to Bombay.
बॉम्बे जाना तो हमको
Thank you, sir. So we have seen that Madam Shyamlha Pappu, she was a versatile lady, and not only she was a dancer, but we know that she was a very good singer also. And in ladies' barroom, we used to say her nightingale. So she used to sing very well, and we have all seen her activities and activities. So thank you, sir, so much. Now I welcome our guest, Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court, to say something. Justice Vishwanathan was born on 26 May 1996 and 1966, sorry. And he looks very young. It doesn't look that he was born in 1966. So it's not my mistake, he looks so very young. He enrolled.
Taken as read. Parliament was that taken as read.
Enrolled as an advocate on the roll of the Bar Council of Tamil Nadu on 28 October 1988 and transferred to the role of the Bar Council of Delhi. He joined the chambers of C.S. Vaidyanathan, Senior Advocate, former Additional Solicitor General at New Delhi, and he also joined with Mr. K.K. Venugopal, Senior Advocate, former Attorney General for India, and he was designated as a Senior Advocate by the full Court of the Supreme Court on 28 April 2009, and he was also appointed as an Additional Solicitor General of India on 26 August 2013, and finally he was elevated as a judge of the Supreme Court of India directly from the bar on 19th May 2022. And we are very eager to listen to your talk.
Initially, I was very scared of introductions. But after I heard a story narrated by Mr. Pali Nariman, I'm sure Justice Oak and others would have also heard it. I have stopped objecting to introductions because it appears there were three eminent gentlemen who were on the stage. Two eminent Parsi businessmen, and third was Jamshedji Tata. So the compare, but I'm glad you introduced now, but look at what happened here. He introduced the two businessmen very elaborately. And when it came to Jamshedji Tata, since he wanted to say that all of you know him, so he ended up saying, and about Jamshedji Tata, less said the better. Anyway, now it's an absolute privilege, Honorable Elder Brother and guide to me personally, Mr. Oak, Justice Oak, Mr. Adish Agarwala, President, distinguished senior lawyer and a former chamber junior of Shyamlha Pappu ma'am, Mr. Kameshwar Roy, Krishnamurthy, who I know from his childhood, distinguished members in the audience, ladies and gentlemen, a very good evening to you. I deem it a privilege to be invited to give some introductory remarks before you really hear the lecture, because I know all of you are waiting to hear Honorable Justice Oak speak on a topic very dear to his heart. I deem it a privilege for two reasons. One is it's a memorial lecture in honor of Srimati Shyamlha Pappu, who really, in real terms, those days, not just broke but shattered the glass ceiling. You know that if you read the history of the advent of women into education, there's a nice article by Lady Hale, and she traces how first they were not even allowed into college. Look at the metamorphosis. I don't say it to please any of the women, it's a hard historical fact. Then the men told them that you can come into college, but we won't give you graduation. You can't qualify. You just attend classes and go. Thereafter they were given graduation, And you know the fight in Patna with Regina Guha and in Allahabad with Cornelia Sorabji, fighting for their enrollment, and ultimately Cornelia succeeding in getting it. And thereafter, you know, in otherwise male-dominated profession, I don't think we can say it anymore, full complement of women who argue cases very ably, not just seniors. And at that stage, in the late 70s and early 80s, to establish and to be designated as a senior is no mean achievement. And a senior of great repute who produced seniors in her own chamber, male seniors in her own chamber. You have Mr. Kameshwar Rai here, and all of you remember the late V. Shekhar, who was also from the same stable. Apart from other advocates, I have seen Madam in court. She had a very dignified way of presenting her case. She of course had a great command over the English language, and she had a lot of grace in her presentation. There was no cringing advocacy. She would state her point, and she would not compromise with self-respect, back it up with law, and if the court had made a decision, she would bow down and leave the court. No wonder, you know, she went on to receive the Padma Shri, as we just saw. I never realized that she was also an accomplished dancer, and also it was new to me that she was an adopted daughter of Justice Chandrasekhar Iyer, one of the early elevations from Chennai to the Supreme Court, though I think had only a brief tenure of 3 or 4 years, but part of several constitutional bench judgments. So that is one reason. Secondly, you are going to listen to the eminent judges of our court, Justice Oak, to whom this topic is particularly dear. And I don't say it because he told me that. Several of his colleagues from Karnataka, and there are at least 2 of them from the state, and the third who's been a judge in that court, have told us that during the COVID time, the way he facilitated access to justice was phenomenal. I have been told that lawyers were given permission to send emails which would be received as late as 11, 11:30, 12 from the registrar to the Chief Justice, because there's Oak was Chief Justice there, and they would get a reply and the matter would be listed. And the steps he took there to see that access to justice is not compromised in any manner, particularly during the trying times of the pandemic, makes him a very eminent candidate who could speak on this topic, having applied and practiced it in full measure. So those are the 2 reasons I say that it is a privilege. I don't want to come in between you and the speaker whom you are wanting to listen very eagerly. It's an ideal topic. It's a topic which was dear to the late Madam Shyamlha Pappu, the topic dear to all of us, because it is part of the fundamental right. Because if access to justice is not there, you see, all other concepts will be empty formalities. Rule of law will be an empty formality. All other basic structure itself would crumble. So it is a very important topic. It is important that we debate on this and we speak on this and we reiterate this and also address if there are any shortcomings, so that, you know, going forward we redress and provide remedies for the same. So with those few words, I wish the trust and its activities all success. I wish you good luck, and thank you very much for this opportunity.
You can avoid introduction. We will have no chance to hear, my lord. In that, we will have the benefit of that time.
Right, sir. So, sir, before you, we can request our President, Adish Agarwal, to say something.
most respected Honorable Mr. Justice Oka, Honorable Mr. Justice K.B. Viswanathan, respected Mr. K.K. Rai, my brother Mr. Krishnamurti, brothers and sisters, I am delighted that Mr. Krishnamurti has organized the second Shyamlha Pappu Memorial Lecture, and that too by requesting Honorable Justice Oka. As Justice K.V. Viswanathan ji has pointed out, that Justice Oka has been a champion. When email received in midnight can be listed, he has provided such opportunity to the litigant. And here in Supreme Court, we all have observed that how he is behaving with the lawyers, how he is disposing of the cases with smiling face. And that's why Mr. Krishnamurti ji suggested that this second memorial lecture for in the memory of our mother, we should have Justice Oka. And he happily, on first request, he has accepted our request, because he is always with the bar, always with the members of the bar. Once I met Lordship in Pune, I was the Vice Chairman of Bar Council of India, and I was also there in Bharatiya Vidyapith. We were together in one function. So that time itself, not only that when he became Judge of Chief Justice of Karnataka or has come to Supreme Court, the students, teachers, lawyers from every part of Maharashtra, they were appreciating, liking, because I know each of the bar leader in bar council and bar associations in Maharashtra. So I was overwhelmed, and when we are having this lecture, Lordship will be telling how in this 75th year of our this when we are celebrating, so how this is very material. You must have seen now lot of changes have been brought in our working. In the courts, now new amendments have come. I can't pronounce in Hindi these three names. When I was called by parliamentary committee to give evidence, that time we appreciated many changes which was suggested that time, because that time the government called the views of different stakeholders, and I being the president of Supreme Court Bar and All India Bar Association, I was invited that committee and I given suggestion. I appreciated most of the provisions, because people today, we have seen the poor accused, if he was to be sentenced for 7 years, he is suffering in jail for 10 years, because there is none to raise. The jail authorities are also not pointing out to the concerned authority, to the prosecution, that already such and such person is in jail for such and such offence, which is having maximum punishment of 7 years, but he is in jail for 10 years. Now, with the new amendments, all these things have been taken into consideration. Only one thing which I pointed out to this committee, that there is no specific time frame for the magistrate to take cognizance of the offence. Judgment has to be pronounced. The prosecution has to file the charge sheet. All these things are there. Some things have been left, but we appreciate this because time was short, there was no discussion, and these whatever lacunas are there, they will be solved by the judgments or by the amendments. With these remarks, I welcome Justice Oka and Justice Viswanathan for sparing their valuable time, and all of you were very busy. I requested at the last moment, all of you are here, thank you very much.
Now, sir, I request our Honorable Judge, Mr. Justice Abhay S. Goka, Judge Supreme Court of India.
Esteemed brother, Justice Viswanathan, Shri Adi Shyamlha, Chairman of the Supreme Court Bar Association, Mr. Krishnamurthy, who is trustee of Shyamlha Pappu Memorial Trust, senior members of the bar, ladies and gentlemen. As Brother Justice Viswanathan said, this is a subject which is dear to me. And after I saw this small video film on late Shyamlha Pappu, I thought that this was more appropriate subject. It was kind of legal aid work which she has done during her lifetime, for which she received Padma Shri. I believe that even this topic would have been very dear to her. The concept of access to justice has a prime place in our constitution. It is actually inherent part of liberty granted under Article 21 of the Constitution of India. Access to justice is a very wide concept. There are different angles to it. Today, of course, when I am here before this August gathering, I will be expressing my personal views. Please do not confuse between the views of the Supreme Court and my personal views. So today I will be expressing strictly my personal views. See, 75 years of existence of Constitution and 75 years of independence. I always believe that after India became independent and it became republic in 1950, every citizen of India had very high expectations from the legal system which was given to us by the Constitution. The high expectation was that this legal system will provide him easy access to the justice. Access to the justice is not simply filing a case in court of law or lodging a complaint with the police. When we say access to justice, it has to be a quality and expeditious justice rendered at a reasonable cost. Merely allowing somebody to file a case does not mean that we have granted him access to justice. So 75 years of existence of our Constitution, I always believe that we must look back and virtually conduct audit of how the courts have performed to find out whether the courts have really achieved what common man wanted the courts to do, or whether we have really fulfilled the expectations of the common man. As a judge of the Bombay High Court and as Chief Justice of Karnataka High Court, and even today, I firmly believe that judges should not stay in ivory tower. And as a judge of Bombay High Court, I had number of opportunities to go to taluka places, to visit district places, interact with the lawyers, interact with the litigants coming to the court. Then I was part of the setup of Legal Services Authority. When in 2018 and 19 we had 3 mega legal services camp in most difficult areas, remote areas of Maharashtra. One was in Naxalite dominated area, where we invited more than 25,000 people to the camps, and we ensured that they get several benefits of various schemes of the government. So, and I've been going to so many law colleges, law schools. So I have been interacting with all stakeholders, and my personal view, which I can gather from my interaction with all the stakeholders, is that the judiciary has not fulfilled the expectations of common citizen of India. In fact, we are lagging far behind. Maybe during last 75 years, in functions like this, where bar and bench were together, we kept on patting our own back by saying that, judiciary is the last resort for common man. Common man has faith in the judiciary. My personal view is that whatever faith was there in maybe 1950, it has eroded considerably due to various reasons. And the main reason, of course, is that we are not able to provide proper access to the justice, a quality justice and a justice at a reasonable cost. And therefore, in my view, we must find out where we have gone wrong. For all these years, we kept on saying that judiciary has done a good job, as I said, last resort of common man, etc. Therefore, we never applied our mind to find out where we are going wrong. Now we have to analyze where we have gone wrong. We have to also find out what we should have ideally achieved. I personally believe first reason which I will give you for not fulfilling the expectations of common man. The first reason is that we neglected our trial and district courts, which are the primary courts in our system. All along, I have been part of legal fraternity for last 40 years, 20 years as a lawyer, 20 years as a judge. Prior to that, I was a student of Government Law College. There used to be workshops, seminars, where members of legal fraternity used to attend. I have seen people talking only about High Court and Supreme Court, as if the trial courts do not exist. So we have not given the importance which our trial and district courts deserve. There is one indication which will prove how we neglected these courts. For years together, we used to describe these courts as lower court, subordinate court, etc., etc. Now there can't be any lower court as such. Every court is a court. There may be a hierarchy for the purposes of appeal, for running the administration, but there is nothing like lower court or subordinate court. In fact, I always believe that the real place where common man gets justice is our trial courts and maybe first appellate courts, district court. The reason is, the statistics will tell you the story, that in so many cases we come across, though a litigant does not succeed before our trial courts or first appellate court, he does not go to higher forum for various reasons. There are social reasons, there are economic reasons. Access to justice is one issue. So for a common man who cannot afford to have multiple litigations, perhaps these are the courts which are the final courts. And look at how we have treated these courts. All of you know that there was 5th Pay Commission, 6th Pay Commission and 7th Pay Commission. Of course, Pay Commission doesn't cover the judiciary. So last 5th, 6th and 7th Pay Commission, I can share what actually happened. After Pay Commission was implemented for government servants, the government thought it fit to amend the law and enhance the salary and remuneration payable to the judges of the constitutional courts. But in case of all 3 pay commissions, there was only one class of public servants which was the last to receive benefit of enhancement of pay, and that was class of our civil and district court judges. Even after 7th Pay Commission, recently, under the orders of the Supreme Court in 2022, a direction was issued to pay salary at enhanced rate to our judges of the trial court and district courts. All other classes of public servants had received the benefit of Pay Commission 2 years earlier, even before onset of COVID. And the government does not do it on its own. On last 3 occasions, it was the Supreme Court which had to pass a judicial order. Yesterday or day before yesterday, you must have read, Supreme Court has now passed a judicial order providing for various amenities and perquisites to the judicial officers. So therefore, this is the way we treat our courts which are real courts. In fact, I always, when I address the judges of our trial courts, I always tell them, don't carry inferiority complex. You are doing the same job, equally important job, which judges of the constitutional courts are doing. So this is one reason why we are lagging far behind. We are not able to provide proper access to justice because we have not strengthened our courts at grassroots level. There is one more reason, which is one of the core reasons why we are not able to provide effective access to justice. In 2002, our Supreme Court ruled that in India there should be just to population ratio of 50. So 50 judges per million for 10 lakh population. And direction was to achieve this target within 10 years. So by 2012, the judge to population ratio in India ought to have been minimum 50. Today, we have not crossed 23 today in 2024. And look at the other jurisdictions all over the world, developed countries where they have just to population ratio of 80, 90, in some cases more than 100. Today in 2024, we are struggling at 23. There was one more effort made by the Supreme Court in one of the decisions in the case of Imtiaz Ahmad. The Supreme Court laid down a formula for calculating the judge strength, how required judge strength is to be calculated, and direction was issued by the Supreme Court to every High Court. High Court should constitute a committee. Committee should work on the formula and submit a proposal to the state government for increasing the number of posts. I happen to be the chairperson of the concerned committee in Bombay High Court. Going by that formula, we found that additional 12,000 posts of judges of various categories will have to be created. So we thought that though Supreme Court says it, we are too ambitious. So we reworked the whole thing, and our proposal was for some 8,000 additional posts. Now this was done, I think, in 2016 or 17, pursuant to the orders of the Supreme Court. Other day I inquired, I went to Judicial Academy in Maharashtra. I was told that out of 8,000 posts demanded, the government has so far sanctioned some 652 posts. So not even 10% of it. And then the other reason is that where is the infrastructure? In most of the states, the infrastructure of our trial courts is so poor. And in Maharashtra, for example, for 3 years, Chief Justice constituted a special bench headed by me to deal with infrastructural issues of various courts. So under the orders of my bench, about 11 district court buildings were constructed. We issued writ of mandamus, and it was like a continuous mandamus. So we ensured that not only construction takes place, but actually the utilization starts. And this is so in several states. Karnataka is one exception where government gives perhaps best possible facility to the court. But Karnataka is an exception. So I always give one very interesting example. I'm told that is so in various states. In Maharashtra, in all district places, there is a designated place where all top government officers and judges have their residential quarters. The district collector, the commissioner of police, or the superintendent of police, the superintendent engineer of PWD, everybody is together in one locality. So whenever I used to go and visit many district places in Maharashtra as maybe administrative judge, guardian judge, or for official work, I used to always go for a walk in that area. And I have said so in my public speech in Bombay and in Karnataka also, that if you don't see the nameplates on the houses, it is very easy to identify the occupant of the house. I always notice in Maharashtra, the best maintained house is of the executive engineer or superintendent engineer of PWD. Then second category is of collector, commissioner of police, etc. And the worst houses, you can say that for sure that they are houses of judicial officers, where tarpaulin is used to cover the house from leakages, etc. So this is the state of affairs. We always kept on thinking about our constitutional courts and did not pay any heed to the requirements of our grassroots level courts, which are the courts of common man. To some extent, even the legislature has contributed for clogging of our trial and district courts or sessions court. all of us know section 138 of the Negotiable Instruments Act. A pure civil wrong is converted into an offence. And look at the scenario. Go to any metropolitan city in India, across India, where either there are courts of metropolitan magistrates or judicial magistrates. You will find that every magistrate has more than 100 matters on every day on the cause list, and maybe 25-30% are 138 matters. That is how the legislature has clocked the system. There is one more reason why our system gets clogged. One reason, of course, I told you, lack of infrastructure, lack of manpower, and these are the kinds of cases with which the judges are flooded. One more area where we must work very hard. There is a remarkable change in our society during the last 20 years, as a result of which you see large number of matrimonial disputes being filed in the court. Go to any metropolitan city like Bombay, Bangalore, I can speak for these two cities. The family court is flooded with divorce petitions and restoration of conjugal petitions. And now what we see is, if there is one matrimonial dispute, there is one or two matrimonial petitions, there is one complaint under section 498A, one proceeding under section 125, one proceeding under section 12 of DV Act, and unfortunately if there are children born from the marriage, then custody proceedings. So one matrimonial litigation is creating 5 litigations at grassroots level, and just count in numbers. Then there will be revision applications, appeals, 482 petitions, 227 petitions. So how much of litigation we are creating? You can see that from Supreme Court, those are practicing in Supreme Court, how many transfer petitions we get. And all transfer petitions, barring few exceptions, are in matrimonial matters. And every case we see there are multiple litigations. Now, these disputes are going to virtually overtake our trial and district courts or our family courts. And therefore, there are people who are genuine litigants, they have to wait in the queue for a long time. So, even the social changes are contributing to clogging of our trial courts. And there is one more area where again there can be a debate. Now, what legislature has done to reduce the filing of cases arising out of matrimonial dispute. Now, some of you know there is a Commercial Courts Act where before filing, conciliation is mandatory. It's a pre-filing conciliation. The legislature could have come out with some such measure before the litigating parties, the husband and wife, go to the court. They could have some effort to conciliate. In fact, making a little departure, in Bombay High Court we started an experiment. When I was chairperson of the Legal Services Authority, we set up a center known as Let's Talk. We invited all leading universities like Bombay University, TISS in Mumbai, SNDT University to depute their heads of the Department of Psychology. And through them we procured services of expert counselors. And the scheme is, we told the police, we called police, they are social security branches. The moment a wife or husband comes to you for filing complaint, please refer them to this center, Let's Talk. So that even before legal proceedings are taken, our counselors will try to either patch up the dispute or maybe convince the parties to have a golden handshake, in the sense that apply for dissolution of marriage by consent. For 1 year it worked. It is working in Aurangabad and some smaller places. But such experiments have to be done on larger scale, and such experiments must be backed by provisions of law. So legislature will have to step in and will have to ensure that before parties start litigating in matrimonial dispute, that this kind of an avenue is available where parties can bring about settlement. There is one more aspect of the matter. I always believe that our courts and legal system exists for common man. But look what we have done. Now we have Commercial Courts Act, a separate setup for commercial disputes, separate procedure. and we received communications from Government of India to establish dedicated commercial courts, and Bangalore was the first city where we had dedicated commercial courts, very modern courts with all the amenities. The question which I asked myself, I may be wrong there, these commercial litigation does not constitute even 5% of the total litigation in India. So why are we giving priority to these commercial cases when cases of common man are not reaching in the court? So this question we have to ask to ourselves and to legislature also, that in country like India, where for smallest thing person has to go to the court, what is the propriety of creating a special class of commercial cases and providing that cases should be given priority? So now we have, just see the provisions of Commercial Courts Act. Now almost all our senior civil judges, now they keep on giving priority to the commercial cases because they are a time-bound schedule under the Act. Now there are reasons and reasons. One example I'll give and I'll go to the next topic. There is a prohibition law in Bihar. So prohibition law resulted into filing huge number of bail petitions. So speaking percentage wise, the filing increased by 30 to 40%. And therefore we had a scenario where more than half of the judges in Bihar, they take up bail matters or maybe quashing matters. So these are the legislations also which bring about a situation where common man is deprived of access to justice. Now there is one more area where we are lagging behind. We are not able to have a consistent policy about our priorities. You know, there are various categories of cases filed in the court. To give an example of a civil court, there is a simple money suit, there is a suit for partition, there is a matrimonial dispute, there is dispute over inventory rights, there is dispute over specific performance of the contract, so many cases. Now, we don't have a policy which decides which cases should be given priority. I remember a few years back, Supreme Court said, give priority to cases of all senior citizens. It is beside the point, but I always feel that how age of 60 years can be age of a senior citizen. The passage of time.
Increase.
That's it. Now, very funny directions were issued by all high courts. Every court should give priority to the cases of senior citizens. So in Bombay High Court, I used to get applications when I used to preside over second appeal bench that I have filed appeal 6 months back, I am senior citizen, this is the order of the Supreme Court, give priority. I used to ask one question to everybody. In every high court, there is a huge pendency of second appeals under section 100. And in most of the high courts, the pendency is for 20 years, 25 years or even more. So in all these second appeals, because by the time matter reaches the stage of second appeal, already 10-15 years are consumed. So in all second appeals, without exception, you will find that the litigants are second or third generation litigants. So today, a question is, are you going to give priority to cases of third generation of litigants? They inherit the litigation along with the property. Or are you going to say that no, somebody is 60 years old, give him priority? In fact, this issue used to arise every day when I used to preside over family court appeal bench. There are many applications used to. Bombay is a very funny city, you know. There are cases where the couples who are more than 60 years, they go to family court, start a new fight at the age of 60 also. So I used to receive applications, say, sir, I am senior citizen, give priority to my family court appeal. So I used to always tell them that, look, you are senior citizen, if priority is to be given, I will give priority to a family court appeal where parties are in early 30s. Because if I resolve the dispute, they will be able to start leading a new life. The example which I am giving you is just to indicate to you that we do not have a policy about our priorities. Maybe we judges feel that, how can we discuss policy? How can we encourage upon each other's judicial jurisdiction? Therefore, we don't discuss that. If we want to improve the access to justice, someday we have to come out with a rational policy of giving priorities. And then that usual thing happens. Somebody goes to Supreme Court, somebody goes to High Court. When we pass orders, decide a case within 7 days, decide a case within 15 days, 20 days. This happens routinely. So somebody who can afford to engage a good counsel in higher court gets priority, and all other people, those who can't afford, they patiently wait in the queue. This happens because we don't have that sense of priorities. What are our priorities as judges? Maybe priorities will differ from jurisdiction to jurisdiction. Maybe some family court, for example, family court will have different category of litigations. The policy of priority will be different in family court. Which cases are to be given priority? There is one more area of concern. Now there is a priority given to criminal appeals of those who are languishing in jail, appeals against conviction. So we give them priority because they are not on bail. While we do that, we say that those who are on bail, maybe in 302 case, there is no urgency in the appeal. Practically in all leading high courts, you will find that there is pendency of 15 years or 20 years of appeals against conviction where accused are on bail. And look at the disastrous consequence. If you don't hear such matters by giving priority, after a gap of 20 years when the High Court confirms the sentence, say a life sentence, after a gap of 20 years the person has to go to jail and undergo punishment. Now 20 years is a huge span. People move ahead in life. And suddenly the case reaches, and if a clear open and shut case is there, we are bound to say that yes, 302 is proved and therefore he has to undergo life imprisonment. So there also we have to think about our priorities. Perhaps we have to balance both the categories of appeals. Now, one solution for improving access to justice was found by legislature by legislating Legal Services Authorities Act 1987. In fact, the concept of legal service under the Act is completely different. It is not merely about giving assisting parties to file a case or in a court of law, to defend a case in court of law. It is something more, the legal services. I'll make little departure from this. I refer to the camps, mega legal services camp which we held. Now we thought that what is legal service? There are schemes of the government. I'll tell you, one is Sanjay Gandhi Niradhara Yojana. There is a scheme of the government where if you are below poverty line, you will get a cooking gas cylinder and some other equipment in kitchen. Some farmers get some equipment, agricultural implements. So we realize that though these schemes are there, the common man, the poor person, he does not know that schemes are available. So what we did was, we ensured that all these people who are entitled to this benefit of scheme, they applied for benefit of the scheme. And we ensured that 1 month before the camp was held, actually these applications are cleared. And when all these people, about 30,000 people appeared, notionally we distributed the certificates, making them entitled to that scheme. In fact, startling experience I have, kind of world in which we live. We had set up a counter for Aadhaar card and PAN card. Half of the persons, we had one camp in Naxalite dominated area near Nagpur. Half of the persons were not aware what is Aadhaar card. Forget about PAN card. Though by that time there was a rule that your account will become inoperational if you don't have Aadhaar card. So this is a wider concept of justice or legal services. And this wider concept is incorporated in the Legal Services Authority Act. Now, who gets legal aid under the Legal Services Authority Act? Section 12 provides for various categories. One category is that one who belongs to scheduled caste or scheduled tribe, a woman, a child, then victims of mass disaster, ethnic violence, caste atrocities, etc. They are all entitled to free legal aid. There are several categories. Now, one category is very interesting. Now, today, one reason why a person cannot afford to approach the court of law is poverty. Now, we need to amend this section. There is a clause in section 12 which says that in case of a poor person or belong to weaker section, we call them actually weaker section of society, under clause 8 of section 12, he will get free legal aid for filing proceedings in all courts except Supreme Court, provided his yearly income is less than 9,000 rupees. So his monthly income is less than 1,000. In Supreme Court, I believe it is 12,000. This requires amendment. Now today the rate of minimum wages has gone up. But here we are lagging behind. In fact, very interesting move was made. I am not able to get information by the Supreme Court. Brother Justice Vishwanathan may be aware of that. The Supreme Court felt that those who belong to middle class of the society, they are not able to afford lawyers, and therefore a society was registered under Society Registration Act.
Society, Supreme Court middle income group.
Correct. Now I don't know how far it is functioning
It
effectively.
is functioning. I was secretary and treasurer.
Correct.
It is one of the very good schemes because
That's it.
many get out of this income bracket and they are unable to afford the fees.
So today nobody can get covered by this.
So for 15,000 plus 15, they are able to get service throughout. A number of people are availing it. Only the problem is, unlike the Supreme Court legal aid, middle income has no grant.
That's right.
So they go by the money which the litigant gives or costs ordered by the court.
At that time, what we felt was for High Court, we constituted a panel of lawyers. We used to ask them to appear pro bono.
So now in your role, the suitors fund whenever there is no claim.
Right.
I sent it, but I disclosed to them that I was once a treasurer.
So therefore, whether Legal Services Authorities Act has really made access to justice more easy. And as Brother Vishwanathan has said, this is one class of the society, middle class. Somebody, somebody is a small-time worker, somebody is a small-time trader, somebody is a primary teacher. If they are required to go to the court, how they can afford to engage a lawyer? And it's not engaging lawyer in one court. We have hierarchy of appeals, revisions, etc. Before I close this topic, only one illustration I will give you. In 2012, I was sitting in Aurangabad bench of Bombay High Court, heading a writ bench. So we used to receive so many petitions for writ of mandamus. In Maharashtra, there is a scheme of the government that certain schools are fully funded by the state. So salary of the teachers and all of the expenditure comes from the government. But there is a rule which says that if in such school a teacher is to be appointed, he cannot be appointed without prior approval of the education officer of the Jilla Parishad. And we were flooded with petitions that asked the education officer, issue writ of mandamus directing him to grant permission. So I thought that why we should be flooded with such matters. My colleague was a very distinguished judge who was born and brought up in that Marathwada area. He said, sir, this is a very genuine difficulty. Because if the teacher starts teaching, because there is no approval, he doesn't get salary. And somehow now impression is that instead of going repeatedly to visit the office of the education officer, it is cheaper to engage a lawyer and get a writ of mandamus from the court. So for these small things also, people have to approach the High Court. And that is where this legal aid for the middle income age group becomes very relevant. I know that we are running out of time, and I want to close by saying something different. I have just highlighted areas where we have gone wrong. This is only by way of illustration. It requires great deal of research, collection of data to find out exactly where we have gone wrong and exactly why we are not able to fulfill the aspirations of common man. There are a lot of expectations from the entire setup of judiciary. When I talk about judiciary, it also includes the lawyers. So there were expectations. Those expectations remain. But somehow there are many who feel that we have let common man down. There is one more very important issue which even exists today after 75 years of independence. We talk about helping somebody to go to the court. And we talk about what is known as docket explosion. So there is a docket explosion all over courts in India. But even today, please talk to those who work at grassroots level of the District Legal Services Authority or Taluka Legal Services Authority. Even as of today, by reason of maybe social reasons, maybe economic reason, maybe any reason, today there is a large class of citizens who even do not think of approaching the court of justice for getting justice. And they keep on suffering the injustice silently. So docket explosion is one challenge to the access to justice, but this is also a challenge where only legal services authority or some social organization can do some work and ensure that people do not silently suffer injustice. So this is just a broad view of the present status of access to justice in our courts. The idea of saying all this is to start a thinking process. I have been saying this in all conferences of the legal services authorities. Whenever I address the judicial officer and judicial academies, I have been making them aware of where we are going wrong. So I thank the organizers for giving me this opportunity to interact with all of you. And I am glad that now, even on a working day, this small hall is full, the complete audience here. So I again thank the organizers, and I hope and trust that Shyamlha Pappu Memorial Trust continues these activities. Only one suggestion which I want to make. Next time when you have such a lecture, please get in touch with all the law clerks associated with the judges of the High Court at Delhi, Supreme Court. Then there are interns. They will be extremely beneficial. Right.
But this will be on the YouTube also. We will circulate.
The YouTube, yes, it's an excellent idea. But for younger members of the bar, interns and law clerks, to remain present physically is a different thrill for them. So again, I thank all the members of the audience. Thank you.
Thank you so much, sir. Now, I request our friends, if you have any question, so we can have a question answer. Right, sir?
Vote of thanks करो सर.
So now, so I request now Shri R.K. Krishnamurthy, Trustee, Shyamlha Pappu Law Foundation for vote of thanks.
Friends, before I begin the vote of thanks, I would request Sapna ji to welcome our P.H. Parekh ji, former President of the Supreme Court Bar Association, 6 times President of the Supreme Court Bar Association. My Lord Justice Oka, my Lord Justice K.V. Vishwanathan, my Lord Dr. Adish Agarwal ji, K.K. Rai ji, our Subramandi Ratta ji, and all the senior members of the bar. One thing, on hearing Justice Oka's speech, I am reminded of a saying by Justice Chandrachud. Then he was a government pleader in 1947. In the
Senior Chandrachud bolo.
Yes, Senior Chandrachud. As a government pleader, and he said, and I quote, that when you read those judgments, you feel you are at a reception to celebrate the wedding of law and literature. Indeed, today, by hearing Justice Oka's speech, we also feel we are at a reception to celebrate the wedding of law and literature. And one more thing, actually, Justice Oka had told about cost and litigation. And here I am reminded of Lord Williams, who once wrote, who was delivering the Tagore Law lecture in 1965. It was from Marshall to Mukherjee, Studies in American and Indian Constitution. And he wrote about the renowned Mr. M.C. Settleward, which all of you know, I think. Once Mr. Settleward was appearing in a matter in the Supreme Court. And he was appearing for a poor litigant. Justice Mukherjee has humorously observed that how the party could afford the services of the Attorney General. Settleward responded, "My Lord, the Attorney General always does not charge fees." The quick, appreciative retort was, "We are glad to hear that." So those are the fundamental principles, the fundamentals of our judiciary and the doyens of the bar. And with these words, I thank my Lord Justice Oka for giving the reception to us, and my Lord Justice K.V. Vishwanathan, who also has given a very illustrative view of access to justice, and Dr. Adish Agarwal, President of the Supreme Court Bar Association, and K.K. Rai ji, and all other senior members of the bar. Thank you once again.
यही इतना टाइम है उन लोगों के पास, उन लोगों का इतना टाइम है।
आपने बोला
आइए ना।